individuals have recently been arrested. Second. This is a calendar for individuals that have been recently arrested, and the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address several matters, including bond, possible arraignment, or consideration of a possible plea offer if one has been made at this juncture. I'm going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I also want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to an attorney to represent you at this hearing. Most of you should already know who your attorneys are, or you've hired a private attorney. The second thing I want to let you know is that you do have a right to remain silent. That is your constitutional right. You should not make any statements against your interests. Listen to your attorneys and govern yourselves accordingly. All right, we have position one.
Judge, you get my email?
No, I haven't.
Okay.
Let me,
I'll just let you know who recommended it. Don't worry about it.
okay. All right, thank you.
It's the first arrest for number one when you call a case.
This is case number 22 CR 0073331D. Arrington, you're charged at 1 count of simple battery, family violence, and a 2nd count of battery, family violence. The offense date is October the 25th, 2022. All right, state.
Yes, Your Honor. Ms. Falk here. I'm going to be on all the positions, just so the court's aware. State's recommendation on this case is a $5,000 signature bond through pretrial services, $3,000 on the battery, $2,000 on the simple battery. No further violent contact with Kent Arrington. That is K-E-N-T, last name spelled the same. Stay away from 569 Griffin Street. That is Griffin. No alcohol, drugs, or weapons. 1 day anger awareness. This occurred October 25th at the 569 Griffin Street address at around 5 p.m. Miss Arrington, who is the defendant, is the person who called the police, stated that she was trying to get rid of Mr. Arrington's items when he pushed her. When they spoke to Mr. Arrington, he stated that while they were arguing, the defendant grabbed him on the chest, leaving visible scratches that were visible to the officers, and he then pushed her off of him. When they went back to question the defendant stated she didn't remember who was the initial aggressor, and at that point, the defendant was arrested. The defendant and Mr. Arrington do live together, are married. This is the defendant's first arrest, and we did have an opportunity to speak with Mr. Arrington, who stated he would like the defendant to come back home to help him due to some medical issues, and reiterated that he was not the one that called the police, but rather the defendant. And so for those reasons, we are recommending that $5,000 signature bond through pretrial. That's all.
And what was the contact recommendation, Ms. Falk?
No further violent contact due to the medical issues that Mr. Arrington is stating he has that he needs assistance with.
Okay. All right, and Ms. Thomas?
Yes, Your Honor, can you hear me?
Yes.
Okay, great. Your Honor, we will also be asking for the signature bond. I believe Ms. Arrington is recommended through pretrial. Ms. Arrington did express that her and her husband have been married for the past 15 years. We will be asking for no further violent contact, but also that she be allowed to return to the marital home. Again, if Mr. Arrington needs assistance, I'm not sure how Mrs. Arrington would be able to assist him. But also she expressed that she does not have any other family living in Atlanta. So it is a necessity for her to return back to the home. She does have 2 sisters residing in Georgia, but again, none of which live in Atlanta. Miss Arrington is 61 years of age. She has been a Georgia resident her whole life. She has children. She completed the 12th grade. Ms. Arrington is unemployed, but she was recently retired from the Department of Family and Child Services in DeKalb County. As we heard from the state, she doesn't have any criminal history, Your Honor. So we are asking again, or amendable to the signature bond offered by the state, but we are asking that she be allowed to return back home to her husband.
State will withdraw the stay away provision.
Okay,
Thank you.
all right. So I will order the $5,000 signature bond through pretrial. That's $3,000 on the first charge, $2,000 on the second. I will order no further violent contact with the victim, Mr. Kent Arrington. I'm going to order that one-day anger awareness course through pretrial. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to allow you, Ms. Arrington, to go back home. A lot of times we don't like to do that because we want to make sure there's been some cooling off period. But I'm going to trust that there will be no more incidents, okay? All right, that should conclude this matter unless council has anything else that I need to take up.
Nothing
No,
else, Your Honor. Thank you.
All right, thank you.
All right, so position 14, Ms. Reese.
And Your Honor, the state has an unusual request as to this chart, as to this case.
Mhm.
We have upon reviewing the warrant, it appears that this is a felony case. The drug at issue is alleged to be Percocet, which is a controlled substance. I have spoken to the officer. He is taking out a felony warrant. He was in process as of noon when I spoke to him and taking out that felony warrant. So we would ask for a one-day continuance so that it can be heard before felony first appearance, at which point the state will null cross our charge.
All right. I will grant that one-day continuance so it can move on the proper channel. We'll reset it. We'll say we'll reset for tomorrow, but it should be done so that it can go over there tomorrow. Is that
According
correct?
to the officer, the warrant will be uploaded by this afternoon and it will be able to go before first appearance tomorrow.
Okay. Gotcha. All right, that'll be fine. Anything that you want to say, Ms. Holt?
Your Honor, we would object because of the fact that, I mean, this warrant has been outstanding for over a year now. And to now all of a sudden make her stay, this is a woman who has no criminal history other than a 2009 missed traffic date. She's an RN, she has family here, her sons go to school here, and now you're gonna make her wait yet another day in jail because someone made a mistake. You can certainly go ahead and do this and then they can close it out and re-accuse it as a felony case. I mean, obviously there's no urgency here. This case is old. She had no idea these warrants were even taken out. She had quit the job that they were talking about 10 days before they even went out and took a warrant out on her. She was given a call by a detective some weeks later who said that if there was going to anything happen, they would give her a call back. So to make her wait yet another day in jail because of a mistake on such an old warrant that is clearly what was in it was already there, Your Honor.
And Your Honor, the issue that would be presented by this is if Your Honor wants to go forward on this case, although I would argue we don't have jurisdiction over this case, what will inevitably happen is that she will be released. The warrant is being taken out. She will be rearrested and sit another day in jail until she goes to felony first appearance. I would prefer that not to happen. I would prefer for her to just go before felony first appearance tomorrow and handle the new warrant.
All right, your objection is noted, Ms. Hogue. I'm going to defer to the state and we set it for in the morning for the felony court. Is the offense date is October the 11th, 2021.
That is correct, Your Honor.
That's
The
what you
warrant,
all have?
yes, the warrant was taken out and then she was arrested a year later.
Okay.
Your Honor, they would not have to rearrest her. Once she was given a thing here, then they can simply transfer the case to felony. There's no rearrest. We have cases transferred to felony all the time, and they don't have to rearrest and go before a first appearance.
We're rearresting because he is taking out a new warrant, PD Hogue. This is not going to be a transfer. He is executing a new warrant as we speak. So that
And we get
warrant
that
will be
as well.
uploaded, it will be placed in the jail, and she will be rearrested on a new warrant.
It's not
That is
necessary,
different than a
but apparently
transfer.
that's what y'all want to do.
All
State
right.
has
Thank
nothing
you.
further.
Okay, thank you. All right, we will reset for tomorrow, but knowing that it'll probably be on the felony calendar in the morning, but we'll note that. Anything else?
Nothing from the state. Thank you, Your Honor.
All right, thank you.
Position 19, Webb. Put your mask up for me, Webb.
All right, 19.
Yes, Your Honor, Ms. Webb has been given an offer from the state that I was not able to communicate to her because I'd already interviewed her by the time I received the offer. So I'll need some time, possibly in a breakout room, to discuss the offer with her to see if she would like to take it.
Okay, who do you have up next, Deputy, if she goes into the breakout? Making sure it's not one of Ms. Hoag's cases. We can go to another one so she can relay the offer.
Ms. Hall, you can call, or we'll call you. You can call 404-612-2392. Have a seat over there. Call Ms. Webb.
Okay.
Position 4, Davis.
Okay. This is 22 CR 0073332A. The charge is theft by shoplifting is at Barry Davis. And the offense date is 10/25/2022. Pretrial.
15 total. The last arrest was 2019 probation. On probation for simple battery out of state court. That should end in December. 2018 simple assault, family violence. We got another probation violation. 2015, 2009 probation. We got simple battery conviction trespass from 08. The last theft arrest I see is a 07 theft by receiving auto.
Okay, that's it.
Yes.
Okay, thank you. Ms. Falk.
Yes, Your Honor. This happened yesterday at 5000 North Point Circle in Alpharetta, Georgia, at the Macy's. The defendant took 2 Dior fragrance gift sets with a total value of $362 and passed all points of sale with those items, depriving Macy's of the value of those items. As the pretrial has stated, this defendant does have previous theft convictions. He actually has, this is his second lifetime theft by shoplifting, with one in 2003. He has a failure to appear from 2003 going forward on his history. As pretrial stated, he is currently on probation for an offense. He has another probation violation that looks to be from 2009. And then again in 2019. And so all told, Your Honor, it looks like the defendant is not a great risk on probation, or is not really willing to follow the recommendations of probation and of his sentences. I also saw a probation violation in 2015. The current bond on this defendant is a $2,500 surety bond. The state would recommend a $1,000 surety bond. Stay away from Macy's, located at 5000 North Point Circle, Alpharetta, Georgia. We are also asking no alcohol, drugs, or weapons, and an anti-theft course. Thank you.
All right, Ms. Thomas.
Thank you, Your Honor. Your Honor, I'm asking for a bond amount no more than 1,000 for Mr. Davis. He did express to me that he would not be able to make this high bond, and he's unsure if his family would be able to assist him. Right now, Mr. Davis is working various of odd jobs. He's employed at Staff Zone, which I believe is a temp agency. Currently, Mr. Davis is 43 years of age. He's been a Georgia resident all of his life. He does have family residing here in Georgia. He's a proud father of 2 children, a 10-year-old and an 11-year-old. Mr. Davis also expressed that he did attend some college. He went to Central Piedmont Community College. Your Honor, we are aware of Mr. Davis's priors. However, again, he is not financially able to make the current $2,500 bond. So we would be asking for a reduction, a bond no more than 1,000. And obviously we are not opposed to the stay away.
All right. I'm going to order the surety bond, and I'm gonna order that in the amount of $2,500. I'm going to order no drugs, alcohol, or weapons while on bond. Stay away from 500 North Point Circle where the Macy's is in that mall. Is that North Point Mall?
It may be, I know it's 5,000 North Point, Your Honor.
1,000, okay.
And I believe that is North Point Mall. That is correct.
Okay. And I won't order the theft class at this time. Because I'm not sure where he'll have to go to take that or where he will go to find it.
And Your Honor, can we get the SAP dates?
Oh, we didn't say that. Thank you, Mr. Holland.
I believe it's
sure did.
November 8th.
Okay,
Yes,
November
we
8th,
discussed
Mr.
it
Dwyer.
prior. It is November the 8th.
okay,
Thank
thank
you.
you.
Mhm.
Come on, Ms. Webb. Position 19, Webb.
Oh, was that all? For that person?
All right, this is 22 CR 007348F. State versus Angela Webb. 1 count of willful obstruction of a law enforcement officer. 2nd count criminal trespass, both with the offense date of 10/22/22. And Ms. Hogue, you were able to speak to your client. What say you?
Yes, Your Honor, I did. I conveyed the offer to her. She is choosing not to take the offer today.
Okay. Pre-trial?
7 total. Last arrest was back in August. Trespass in Cobb County. That's open. Also has an open ag assault, another criminal trespass, and an open trespass in DeKalb County. So all of her, all 7 arrests come from this year, starting in March. They're just trespasses. March 31st, trespass conviction. April, trespass conviction. May, trespass arrest. August, that was the ag assault. And the August trespass. So that's it.
Okay. Ms. Falk?
Didn't realize I was unmuted. Yes, Your Honor. I'm seeing also that she has a criminal trespass that she was booked in on here at the Fulton County Jail on May 25th. And I just wanted to look that up really quickly and get that bond information for the court. She was arrested May 25th on that charge for criminal trespass at the racetrack. She was on that case given a $1,500 bond recommended by Judge Osby. I may be saying that incorrectly, OSBY, let's see. And in that case, I just wanted to see if the status was still open.
Okay,
It looks as though that case is still open under 22 CR 00333-6F. And that was a $1,000 SOB through the jail. And she was told to stay away from racetrack on Piedmont. This case happened. Just give me a moment.
mm-hmm,
This case occurred at the Quick Trip, and that was located at 4975 Windward Parkway in Alpharetta. In that case, officers arrived to the location again because of criminal trespass. The business had asked her to leave. She had refused to leave. And then they wanted the officer to criminally trespass her at that point. The officer then observed the defendant. She began walking away. The officer kept asking for the defendant to stop so that he could, criminally trespass her. She continued to walk away again. And then the officer took her into custody and charged her with obstruction. We did add the charge of criminal trespass. The current amount on this case, Your Honor, it looks like there is no bond on this case for the willful obstruction. The state is recommending a $1,000 surety bond, $500 on the criminal trespass, $500 on the willful obstruction. There does seem to be a significant history here of criminal trespass, and she does currently have that open case as well as this new case. For those reasons, that is why the state is requesting this bond. Thank you. Oh, we're also asking that she stay away from the Quick Trip and no alcohol, drugs, or weapons. Thank you.
all right. And Ms. Holt, this is your case?
Yes, it is, Your Honor.
Okay, go ahead.
Yes, Your Honor. Ms. Webb is 22 years old. She is born and raised here in Atlanta, Georgia. When she was 17, she graduated from Frederick Douglass High School. And when she was 17, both of her parents died. She does have a sister here, so she does have connections here and a place where she can stay and live and get, get mail and be able to get all of her court notices. So since 17, she and her sister essentially have been out on their own. They've been, she's been doing everything she can to support herself. So it's been very tough. So she is obviously financially limited. She can get help from her sister, but still, that is still a very difficult situation. I understand asking for a signature bond in these cases is, pretty tough, but signature bond would be greatly appreciated. Otherwise, we do agree with the $500 minimum bonds on the charges.
Okay. I'm going to order the $1,500 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order the stay away from the QT on 4975, I'm sorry. And I think it was, what was the street?
Windward Parkway.
Windward
Thank you,
Parkway.
Ms. Bridgewater.
Thank you. Stay away from there.
Will you break down the bond, Judge, please?
That's
Your
what I was
Honor?
going to ask. Thank you, Ms. Bridgewater.
Yeah, and I believe that the state had asked for 500 on each charge, or did I mishear?
Oh.
No,
did I-
that was the state's recommendation. 500 is to each $1,000 total.
Yeah.
Okay, I'll defer to that. Thank you, Ms. Hogue. Ms. Bridgewater, make it $1,000 surety bond, 500 on each. Stay away from 4975 Windward rather, Parkway, which is a QT. Stay away from there. Ms. Webb.
I-
No drugs, alcohol, or weapons while on bond.
The state does have another request. Obviously, it doesn't need to be part of the order, but if it's possible, I don't know if PD Hogue has already sent out a social worker to visit with Miss Webb, but given the charges that are kind of building up, I think it would probably be helpful.
It's in the process.
Thank you. Also, Ms. Bridgewater, can we add the companion case to the reset SAP, that 22 CR 0033336F case?
Got it.
Thank you.
Mhm.
And the state's withdrawing our recommendation on the this case. As far as our outstanding recommendation, we are withdrawing that.
Okay, great, thank you. All right, does that conclude everything with disposition 19?
Yes, Your Honor. Thank you.
Just for the defense, Your Honor.
All right, thank you.
Position 9 and 10, Mr. Jones.
First case I have is 22 CR 0073338C, Elijah Jones. You're charged with 1 count of battery, family violence, the 2nd count of terroristic threats, both with the offense date of June 21st, 2020. State, I'm sorry, pretrial.
It's his 8th arrest. Last arrest was in September, South Carolina. Unlawful carrying of a weapon. That appears to be open. He was also arrested in Texas in 2017. Credit card or debit card abuse. That was dismissed. Last arrest in Georgia, 2017, suspended registration. 2015, given false name, dismissed. 2015, misdemeanor possession of marijuana, dismissed. 2015, probation for trespass. Came off of, that's it. So he got the open case. South Carolina. That's it.
Ms. Falk?
Yes, Your Honor. I'm just looking for a moment because I was showing a conviction as to one of the charges, but I may have been incorrect.
Out of Texas?
Yeah, I thought it was a conviction. It wasn't. It was deferred.
Yeah, that theft of property, yeah.
Okay, so there are 2 cases on the calendar, Your Honor. I would like to address both if we may.
Okay, let me call position 10 and then you can give the facts with both.
Thank you.
Position 10 is 22 CR 0073440C. Again, state versus Elijah Jones. You're charged with 1 count of battery, family violence, and 2 counts of cruelty to the children in the 3rd degree. All right, go ahead, AG Falk. Deputy Falk.
Yes, Your Honor. The first case, the one that happened on June 21st, 2020, happened at 160 Bell Street at 9:30 a.m. Jaleesa Price, that is Jalessa, Price, common spelling, told officers that the defendant with whom she shares a child pulled up outside of her apartment to pick up their child. As Ms. Price was walking out their child about 10 minutes after the defendant arrived, apparently the defendant was very agitated, pulled out at a high rate of speed. The defendant and Ms. Price then began arguing via text, and the defendant texted to Price, "You lucky, I'm going to shoot your shit up. Stop playing, ho. And I bet you want to call me a bitch to my face. I'm outside." So at that point, Ms. Price walked outside. The defendant drove up, exited the vehicle with a handgun near his side, and slapped her with an open hand, causing her to fall to the ground. The officers were able to observe a scratch behind her ear. We have had an opportunity to speak with the victim in this case. She stated that they are no longer in a relationship. They do not live together. However, they do share one child. She stated she is still afraid of the defendant, wants absolutely no contact with him. She filed for a TPO after this incident that included their child. And that TPO, we were able to locate it in the system. However, it was not served. She also stated that the defendant pointed the gun at her during the incident and told her that he would shoot her. She further stated she told the officer that at the scene, but the officer told her it'd be hard to prove that he pointed a gun. Furthermore, Ms. Price has stated to us that after this incident, the defendant was posting things about her on social media, even after the TPO she had filed for the TPO asking him not to do so. She has stated that she has since moved from the incident location of 160 Bell Street, and that the defendant is now unaware of where she lives. And she stated she is on Zoom, but does not wish to speak. There are, as pretrial has stated, there are 5 cycles in Georgia, 1 in Texas, 1 in South Carolina. Again, that South Carolina arrest was in September of this year for unlawful carrying a weapon, which concerns the state for 2 reasons. One, because it shows a kind of shaky ties to the community that he has a recent arrest out of state. Additionally, it concerns us because this case alleges a gun was involved and he was arrested in September for unlawful carrying a weapon. To that end, and based on this and because of the other case, the state is requesting on this case a $6,000 surety bond. That is a $5,000 bond for the battery and a $1,000 surety bond for the terroristic threats and acts. No further contact with Jaleesa Price. We are asking that he stay at least 200 yards away from her residence, and have no contact via phone, email, text, internet, or any other medium. We're also requesting no further contact with a minor child and no alcohol, drugs, or weapons. Moving on to the second case. That case occurred August 15th, 2022 at 7:10 a.m. at 1220 Mescaline, that is Mecaslin Street, Northwest. In that case, the victim Sheriff Wright, and that's SHARISWRIGHT, stated that the father of her children, who was later determined to be the defendant, put her out of the apartment and struck her. Wright stated that the defendant became upset when he couldn't find his bank card and began yelling at her and told her to leave. Wright told police that her 8-month-old baby, JJ, was in her arms, and the defendant punched her in the back of the head several times, causing her to fall to the floor and scrape her knee, at which point the defendant then left the location. Officers had an opportunity to speak with HJ, who's the 3-year-old daughter of both the defendant and Miss Wright, who stated, "Daddy hit her back multiple times." Miss Wright initially gave the name of Michael Dillard with the date of birth of 12/18/1990, which is the same date of birth as that of Elijah Jones. On September 5th, however, investigator Brown Tony with the Atlanta Police Department called and spoke with Miss Sheriff Wright, who then stated she would cooperate with police once they realized that Elijah Jones was the individual and not Michael Dillard. They called Miss Wright, who stated she would cooperate and confirmed that the defendant Elijah Jones was the person that assaulted her. Wright also identified Jones from a police photo that that investigator Brown Tony sent to Miss Wright. I will state that Miss Wright has subsequently attempted to recant and state that the person, Michael Dillard, was her cousin. However, that does not at all gel up with multiple facts of the case, such as her saying that it was the child's father who hit her, the child, HJ, saying daddy hit her back multiple times, and her subsequent statement to police on September 5th, identifying the defendant from a photo, as well as telling the police that it was in fact Elijah Jones, her father of her child, that hit her that day. So I believe that Ms. Wright may be here today and may have something different to say. However, the facts just don't match up with Ms. Wright's subsequent statements. To that end, we are asking for a $7,000 surety bond, $5,000 on the battery charge, $1,000 on each of the cruelty to children charges in the third degree. We are further asking for no further contact with Sheriffs Wright, HJ, and JJ, since they are also victims in this case, and stay away from 1220 Mescaline Street Northwest, 2430, which I believe is the apartment number in Atlanta. No alcohol, drugs, or weapons. Thank you.
All right, give me the state's recommendation on the breakdown again.
So on this one, it's going to be a $7,000 surety bond, $5,000 on the battery, $1,000 on each of the cruelty to children in the third degree.
All right, PD Thomas.
Thank you, Your Honor. As far as case one, I believe it's count one or
Mhm.
position 9, I believe. Mr. Jones strongly denies those allegations. He also is denying the paternity of said child. He's also denying the allegations that we weren't given in that warrant, but obviously these new allegations that we weren't at liberty to discuss. Mr. Jones does not have an issue with the stay away or no further contact. He does not have contact with Ms. Price. We also are not opposed to having no contact with the child, as again, the paternity of said child is at issue. Mr. Jones does not live with Ms. Price. So again, we're not opposed to a stay away or no further contacts. As far as position 10, we are denying those allegations. However, we would be asking for a third-party visitation and transfer of said children. He is the father of those 2 children. He is denying those allegations, Your Honor. We are not opposed to no contact with Mrs. Wright or a stay away because they do not live together. However, Mr. Jones did express that he does provide for those 2 children. He is involved with their lives on a daily basis. He transports the kids to and from child care, Your Honor. So he is asking for third-party visitation and transfer for the children belonging or shared between him and Mrs. Wright. Mr. Jones is 31 years of age. He does have community ties. He has been a Georgia resident for the past 32 years. Excuse me, he's 32 years of age. He's been a Georgia resident for the past 32 years. He does have family also residing in Georgia. He graduated from high school. Right now, Mr. Jones' income is up and down. He did express that he is self-employed. He does do work as a music producer. However, the finances in which he provides for his children, all of his money goes towards the care for his children. He would not have the means to post a high bond, especially a $7,000 bond or $5,000 jointly. So we are asking, as far as position 9, a bond no more than $2,000. That would be $1,000 on each count, Your Honor, and then a bond no more than $3,000 for position 10, which would be $1,000 on each count.
Your Honor, the state would just like to add that I find it interesting that the defense is stating that they do not live together. Ms. Wright, the victim, states they do live together and in fact live at his mom's house together, which also gives the state some concerns about influencing a witness since they do in fact live at his mother's house.
All right. On position 9, I will order a surety bond for $6,000, $500 on the terroristic threats. I'm sorry, $5,000 on the terroristic threats and $1,000 on the battery for a total of $6,000 surety bond. No drugs, alcohol, or weapons while on bond. Stay away from the address of 160 Bell Street. And
130 Bell Street.
I had 160. Is it 130 or 160? I might have.
It is 160. However, we are not requesting a stay away because the victim no longer resides at that address.
Oh, okay. So no stay away. Okay.
Okay.
And no further contact with the victim, Ms. Price.
And we're also asking that he stay away from the minor child as well. I understand that he's not claiming the child. However, just in case, we'd like to stay away from both.
Okay, and stay away from the minor child as well. And this one, we don't need any third party, because paternity is still an issue, right?
Correct.
Okay,
That is correct.
so if there's nothing else, council, that will conclude that first case. And then on the second case, ending in 340C, I will order the $7,000 surety bond with 5,000 on the first charge and 1,000 on each of the other two, the two cruelty charges. No drugs, alcohol, or weapons while on bond. And in this one, we want a third party facilitator for visitation.
Yes, Your Honor.
And the state would object as the two children are in fact witnesses and victims in this case.
How old are the children again?
The youngest child, the oldest child was 3 years of age at the time of the offense, and the youngest child was 8 months of age.
They're very small. But as long as the third party helps to facilitate it, I'll allow it if the victim wants to do that or not. But just working out your plans or logistics of how you're gonna meet, where, all that needs to be done by someone else with third party. All right,
Thank you.
okay.
No.
Position
And
18.
Your Honor, wait, we're actually also requesting, and I hadn't heard the order yet, no further contact and no alcohol, drug. Oh, I did hear that, no alcohol, drugs, or weapons, but we were asking for no further contact with Ms. Wright.
And I'm sorry, I did leave that off. I apologize. And no further contact with Ms. Wright.
And to stay away from the address.
And to stay away from the incident location.
Yes, the incident location address that we had is 1220 Mesclun Street Northwest, but let me just confirm with our victim advocate that that is the address she resides at. Okay, so we're not getting a confirmation that that is the address she resides at. However, we would just ask for a stay away from that address because the police report states that as the address and the defendant's warrant states that is the address.
Okay. All right, is there anything else to take up, council?
No, Your Honor, thank you.
No, Your Honor. Thank you.
All right, that'll conclude this case. Thank you.
Position 18, Tucker.
This is 22 CR 007374E. Ravshan Tucker, charged at one count of loitering or prowling, offense date 10/25/2022. Pre-trial.
48 total. Last arrest was in September for probation violation. Open case in DeKalb, possession of a Schedule II controlled substance. On probation, possession of cocaine with intent, possession of marijuana with intent, possession of meth with intent. Burglary second degree, possession of a controlled substance. That's all out of Fulton County. On probation in DeKalb for obstruction. August, probation. June, possession of a Schedule 2. February, probation. Judge, anything specific you would like to know? 'Cause it's a
No,
lot.
I think you summarized it. I'm sure the state will tell me some other highlights as well.
Okay.
All right, thank you. Go ahead, Deputy Falk.
Yes, Your Honor. This happened October 25th, 2022, yesterday at 7:40 p.m. This incident occurred at 1087 Lind Ridge, that's LINDRIDGE Drive, Northeast in Atlanta, Georgia. The defendant had actually jumped over the fence of Miss Kanuparthy's home, and I apologize if I just butchered that name. That is Kanuparthi. So the defendant jumped over the fence, the backyard fence, and stayed in the backyard, walking around with a stick in his hand while observing items that were in the backyard of Miss Kanuparthy's home. When officers spoke to him to find out why he was in Miss Kanuparthy's home, he stated that the grass in that yard is softer. And that was the only statement he made. So the state's concerns here are, we've got a gentleman who is 37 years old. Actually, he's 36. He turns 37 next month, who has literally more cycles than he's been alive at this point, including the burglary cycles, which are definitely of concern to the state. We have some serious concerns about why he was in this individual's backyard without permission, and jumped over a fence to get there at around 7 late in the evening. It was about 7:50 at night. Just walking around her yard is of concern for anyone, but in particular with his history is of grave concern to the state. As the pretrials pointed out, we have a number of cycles, including that open burglary case in DeKalb. Also, what the state is seeing on the history is battery convictions, false statements in writings, forgery, probation violations in 2005, failure to appear in 2005, just going forward to his more recent history, drug convictions, obstruction of an officer, theft by taking in 2015 here in Fulton County. We are also seeing again, a number of drug arrests with convictions for possession of a Schedule 4 substance in 2019 out of Douglas County, as well as possession of cocaine in which appears to be a MARTA case, and further probation violations in 2019. So this defendant essentially has a prolific history. The current bond is set at $600, but based on this defendant's history and his almost certain risk of reoffense, we are asking for a $1,000 surety bond, that he stay away from the address, which is 1087 Lynn Ridge Drive Northeast. They have no further contact with Miss Kanuparthy, and no alcohol, drugs, or weapons. Thank you.
All right. Ms. Hodges.
Yes, Your Honor. Mr. Tucker is 36 years old, Your Honor, and he's lived in Atlanta all of his life. He has family ties here, including his mother, who is a nursing aide, as well as his sister. He's had a tough time since the pandemic, Your Honor, trying to find consistent work, and he's worked very hard trying to. He lives with his mom out in Loganville, but sometimes when he is here looking for work in Atlanta area, it's tough to get back out there. So he's walking to a friend's place. And gets a bit confusing at night as it's getting dark, Your Honor. There's no indication from the facts told that he was aggressive in any way, that he was approaching any doors, that he was, doing anything. All it is he had a stick in his hand. When the police asked him a question, he answered, Your Honor. I understand he has cycles, Your Honor, and I guess we can make comments about his age and cycles. I prefer not to. All I am hearing is that latest actual convictions are from 2019. That is 3 years ago, and those were dealing with drugs. And then the closest thing to even a theft was 2015, and that's 7 years ago, Your Honor. So while I do understand that the state has its concerns, Your Honor, I do believe that either a signature bond or the $600 surety bond that was originally ordered or perfectly adequate to make sure that he shows up in court, Your Honor, and is not a danger to the community.
Okay. Anything else, counsel?
No, Your Honor.
Nothing from the state.
All right. So for this matter, I'm going to enter a $5,000 surety bond.
Your Honor, even the state was only asking $1,000. A $5,000 surety bond would just be beyond anything he could possibly come up with.
Okay, you said he was 36 and not working?
That is correct, Your Honor. He's been trying to find work since the pandemic. It's been very difficult.
Okay. All right, I will lower it to the $1,000 recommended by the state. So $1,000 surety bond, no drugs, alcohol, or weapons while on bond. And what was the location again? That Lynn Ridge, that a business or?
It's a residence, Your Honor, 1057 Lynbridge Drive.
Okay.
Is it 1057 or 1087?
Well, I had 1087. Which one?
That's what I have.
Excuse me, 1087. That is correct. My apologies.
Okay. 1087 Lynbridge. Stay away from that location. And
We are also asking for no further contact with Miss Kanu Parthy.
right, I don't know how to pronounce that name. I was gonna let you do it again.
I'll
Sorry,
just
I
spell
know
it for Miss
I'm messing up.
Bridgewater. It's KANUPARTHI.
Okay. And no further contact with the victim in this case. Anything else for this case, counsel?
No, nothing for the defense, Your Honor.
All right, thank you.
Thank you, Your Honor.
Mr. Tucker, I would recommend that you remain silent. If you have questions, I can address them later on today.
Position 20, Williams.
Okay. This is case number 22 CR 0073550A. Kevin Williams, you're charged with 1 count of battery, family violence, and 2nd count of cruelty to children in 3rd degree. The offense date is July the 20th, 2022. Pre-trial,
13 total.
you
Hold
said
on.
15?
13.
Oh, 13.
Last
Okay.
arrest was 2018 probation for theft by taking. 2016 manufacture, deliver, or distribute with intent a controlled substance. Possession within a drug-free commercial zone. 2014 probation. 2014 possession of cocaine. Couple of counts of obstruction. Possession of a controlled substance or marijuana within 1,000 feet of schools. 2014 probation. 2012 probation. 2011 probation. He's on probation. Possession of cocaine with intent and possession of cocaine in a drug-free commercial zone. That's 16 SC 147131. He went to felony earlier and got a $10,000 good bond for the firearm by convicted felon. That's it.
All right, Deputy Falk.
Yes, Your Honor. So this happened July 20th at 9:16 a.m. at 320 Fairburn Road, apartment 3. Jamila Jackson, and that is JAM, Illa, last name common spelling, stated that the defendant, the ex-boyfriend and father of her child, was banging on the front door and attempting to enter. At one point, Miss Jackson finally let him in. The defendant pushed her onto the couch, began choking her and striking her on the right side of her head. The defendant further stated he'd kill her if he did not get his son, name CW, age 1. Jackson then got away from the defendant, and defendant followed her into the bedroom and began pushing her again. At that point, Miss Jackson picked up their minor child CW, and the defendant snatched the child away. Officers did observe a bruise near the forehead of the child. The defendant then fled the location, and Miss Jackson was observed to have visible swelling to her head. We were not able to get in touch with Miss Jackson. It appears that the number we reached out to was not in service, but the state does have some grave concerns, having read the police report in this case that we received after accusation in regards to the facts of this case, including allegations of choking, as well as the injury to the child. Furthermore, we have some serious concerns about the defendant's likelihood of reoffense and his ability to follow the instructions of the court, being that he had 4 probation violations on the same case, which is that 2009 case where his first offender was actually revoked in 2014 due to a probation violation. And he had probation violations in 2011, 12, and 14 leading up to them finally revoking his first offender. He also has, in 2018, his probation was again revoked to 3 years to prison on that case. We also have concerns because of his FTAs. He has 2 in 2010 and 2011 out of Henry and Clayton, and his most recent case where he's still on probation, which is that 2017 VGCSA WID, and with intent to distribute in a drug-free zone. So for all those reasons, our recommendation is $10,000 surety bond, stay away from the address, which is 320 Fairburn Road, apartment 3, no further contact with the victim, which is Jamila Jackson, no alcohol, drugs, or weapons. Thank you.
And the breakdown was set 5 each.
No, Your Honor, with the cruelty to child, we would ask for $2,500 and $7,500 on the family violence battery.
Okay. All right, Ms. Holt.
Yes, Your Honor. Mr. Williams, Your Honor, is 31 years old. He's lived in Georgia all of his life. He is currently married. He has had consistent jobs, Your Honor. Right now, he runs his own car wash business, as well as he's been a forklift operator for 8 years, as well as he's also worked at DHA for delivery for the last 6 months. So he holds several jobs, Your Honor, in order to support his children as well as his wife. He has 3 children of his own and 3 from his wife, so that is 6 children in the household, Your Honor. And like I said, they've been together for 10 years and just recently married. As far as these charges go and as far as his history goes, his history is mainly drug related, other than an obstruction, and most of it is dating back to 2018 and 2016, so definitely 3 and 4 years ago. Given his current situation, this situation happened, according to this, on 7/20/2022. That is 3 months ago. Okay, he completely denies the allegations, including that it was he who went over there. He completely denies all of it. Since that time, he and Ms. Jackson had numerous conversations, numerous transfer of children. She never told him that she had taken warrants out on him at all. And so this came as a complete surprise. So, Your Honor, given the fact that this is 3 months old, he and she have already had many conversations. They do not live together. He has no problem with the no contact. He has no problem with third-party transfer of children, since she's the one that's always calling him to come get children, to come pick them up, trying to drop them off. So though we do ask for a reasonable bond, given the fact that this is a 3-month-old warrant that he was not aware of, he doesn't have a history of violence, Your Honor, and he does have 6 children that they're supporting, as well as his wife, who does do some accounting work, but he is the main support. He does have a $10,000 bond right now that he's going to have to make in the felony area. So we believe that a $2,000 bond, 1,000 on each charge is more than sufficient to ensure that he shows up to court. The stayaways and the no contacts are not a problem, and he is not a threat to her, given that they've had numerous contacts since then, Your Honor. So we do believe that that is more than fair.
Okay. I'm going to order a $5,000 surety bond. With that surety bond, the first charge will be $3,500. The second charge will be $1,500. It's a total of $5,000 to bond. I'm going to order no drugs, alcohol, or weapons while on bond. Stay away from 320 Fairburn Road, apartment 3, I believe it is. And stay away from that address and no further contact with Jamila Jackson. If there's going to be visitation with the child, and that must be done by a third party. Anything else, counsel?
Nothing, Your Honor, other than the address is correct and nothing further for the state.
Nothing further for the defense.
Okay.
Position 11, Love.
This is 22 CR 007341G, Montreal Love. You're charged with 1 count of battery family violence. The offense date is 10/24/2022.
Bianca, I know the bond assessment said it was his first arrest, but that wasn't true. He actually have history out of Oklahoma, Indiana. I think it's somewhere else as well.
And Michigan.
Yeah. I knew it was another one. I'm going with Oklahoma first. 2019 DUI, 2018 DUI, speeding. Michigan assault excluding sexual. That was from August 2015. December 2015, assault excluding sexual. 2017, dangerous drugs. It says liquor excluding traffic, whatever that means. Indiana 2019, disorderly conduct, harassment, criminal mischief. 2020 failure to appear. Another 2020 failure to appear. 2020 criminal trespass. 2020 operating vehicle while intoxicated, 2 counts. 2021 public intoxication and residential entry. That's it.
2 things.
You got
Pre-trial
something?
showing a May 2016 arrest out of Michigan for assault as well, and a July 2021 criminal trespass arrest.
Yeah.
Out of
Indiana.
Yes, out of Indiana.
That's correct.
Okay.
My bad.
All right, so this occurred on October 24th at 11:20 p.m. at 2301 Godby Road in College Park, apartment 4E. Timothy Wright stated to police that while he and the defendant, with whom he's been living with for 1 month, but has been in a relationship with for 4 months, that while they were driving back from Atlanta, the defendant struck him several times in the face with his hands and with a bottle. Officers were able to observe swelling and bruising to the Mr. Wright's face and hands. Our victim advocate did have an opportunity to speak with Mr. Wright. He stated that they are in a relationship. They do live together, that the defendant has some MH issues, and that he was also drinking at the time of the incident. Mr. Wright further stated that this is the second time this has happened. He stated that the first time was last month. The police were called out, but no arrest was made. Although Mr. Wright is okay with contact, we are not. The state has some serious concerns here based on the fact that this only happened We are now less than 48 hours out from this incident, as well as the cycles of assault in 2015 and 2016 in Michigan. The most recent arrest in 2021 for criminal trespass out of this state, which gives us some real concerns regarding ties to the community. And we have some concerns of a risk of reoffense, both because of the 3 arrests for assault, but also because of the fact that Mr. Wright told our victim advocate that this is the second time that this has occurred, the first time being last month. And these two have only been living together for a month and have only been in a relationship for 4 months. So that is a pretty severe amount of activity happening in a very short period of time that gives us some real concerns, coupled with those 3 prior arrests for assault. Furthermore, we are asking, so to that end, because of all of these factors, we are asking for a $5,000 surety bond. We're further asking for him to stay away from 2301 Godby Road, apartment 4E. No further contact with Timothy Wright, 1 day anger awareness, and no alcohol, drugs, or weapons. Thank you.
All right. All right, Ms. Thomas.
Thank you, Your Honor. I spoke with Mr. Love briefly. He is strongly denying these allegations that a physical altercation took place. However, he is not opposed to a no further contact or a stay away. He did express that he does have somewhere else to reside. Again, no opposition to the no contact and stay away. There is no relationship, according to Mr. Love. He also expressed that he has been living in the Atlanta, Georgia area for several years now. He does also have he is also employed at Georgia State University. He works as a dishwasher. He's been there for the past month and a half. And prior to Georgia State, he's been working at the Staff Fulfillment Center, Your Honor. Mr. Love is 24 years of age. He provided a 3350 Mount Gilead Road address as someone where he will be able to reside. We did not have that criminal history. We were not provided that criminal history. It was my understanding that Mr. Love had no criminal history outside of a Michigan offense in which he was 17 years of age at that time. So we will just stipulate to what pretrial has provided. If Mr. Love is not recommended for a signature bond, we are asking for a bond amount no more than $2,000 at this time. Again, Mr. Love is just recently employed at Georgia State. He's been there only for a month and a half. He does not have the financial means or support to make a high bond amount. He told me that he has no other way of getting bond, no family or financial assistance. And being that he just now recently started that job, he does not wish to lose that job. So again, Your Honor, we are asking for a bond amount no more than $2,000, not opposed to no contact or stay away provision.
And Mr. Wright is here on the Zoom in case Your Honor would like to hear from him.
Okay. Oh, I see. All right. Mr. Wright, do you wish to address the court today?
Address the court as far as
Talking about whether you're in fear of Mr. Love, or you have anything you would like to add?
I would like for him to get the help he needs, whether that's me helping him or the court. But I know he needs help, and I want him to get that help.
Okay. Are you in fear of Mr. Love?
No.
Okay. And you all were roommates?
Yes.
Okay. All right. Any cross-examination? I forgot to swear you in.
Your Honor, if you don't mind swearing him in.
Okay. All right. Raise your right hand for me, Mr. Wright. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
Okay. All right. And I'll ask you those questions again. You can put your hand down. Are you in fear of Mr. Love?
No, I'm not.
Okay. And so under the penalty of perjury, make sure you are telling the truth. You said that you're not in fear of him, but you wanted him to get some help. Is that what you just stated?
Yes, ma'am.
Okay. All right. Any cross-examination?
Just briefly, Your Honor, I just want to clarify the relationship between the parties. Mr. Wright, is isn't it correct that the two of you, Mr. Love and you, are in a relationship, not just a roommate situation?
Yes, ma'am.
Okay, and is it also correct that this is not the first time that the defendant has struck you?
Correct.
Your Honor, I'm have to
That's
object.
all
We have
from-
no record of no prior incidents to this alleged incident, Your Honor. So I'm just objecting for the record.
Your Honor, as PD
Okay.
Thomas well knows, this goes to the IALA factors, including risk of reoffense and influencing and intimidation of the witness.
All right. And I will say, Mr. Love, you can put your hand down until I give my ruling. I don't think your attorney is going to want you to speak, all right? You can talk to your attorney.
Yes, Mr. Love, any and everything that you say is going to be used against you. So I do advise that you remain silent. If you have any questions, feel free to give me a call after court has concluded.
Okay.
Myself.
All right, I'm ready to give my ruling. Anything else, counsel?
Nothing from the state.
Nothing further, Your Honor.
All right, I am going to order a surety bond, and I'm going to order that in the amount of $4,000. I'm going to order that the defendant stay away from 2301 Godby Road. Is it apartment 4E, I believe? I'm going to order that there be no further contact with the victim, Timothy Wright. I'm going to order no drugs, alcohol, or weapons while on bond. And I think that is it for now. Anything else, counsel?
4E is the correct address,
Right, 4E.
and that is all from the state.
Okay. All right, that will conclude this case. Thank you, Mr. Wright.
When do I go back to court?
If you don't bond out, it'll be November the 8th.
November the 8th. Okay, the only way I would be able to.
Mr. Love, did we just not admonish you that you should not be speaking?
Okay, so November 8th, we want to have another review on the bond because I'm not able to bond out.
That is correct.
All right, thank you.
Position 13, Niece.
Hey, y'all down, come on, let's go.
All right, this is 22 CR 007343F. Christopher Neese, you're charged with 1 count of public indecency and a 2nd count of marijuana possession less than an ounce, both with the offense date of 10/25/2022. Pre-trial.
One moment, please.
I have the history if pretrial would like an assist.
No, I'm sending the judge something.
All right.
You probably already know what it is, though.
Yeah. Okay,
Let me send it to PD Hold real quick.
all right.
I was going to say, actually, I don't believe I do. So the state, I would ask pretrial to send it to both myself and Ms. Hogue as well.
I don't know, the facts or anything we need to go in a breakout for, are you okay discussing this?
State can manage to work its way around this one, Your Honor.
Appreciate it.
Yeah.
Okay, so this incident occurred October 25th at 9:50 a.m. at 70 Hamilton E. Holmes Drive Northwest. That was the MARTA train car. The defendant asked the victim, who is a patron on the MARTA train, to remove her face mask so he could see her lips. And then after doing that, he committed the act of public indecency. You have already heard from the state's concern is obviously he has a CWAC charge for registry violation. We are also concerned because of a 2020 battery and criminal attempt in DeKalb County, as well as a criminal trespass in June of 2022 in DeKalb. The current bond is set at $5,000. That's $2,500 as to each charge. We are asking for an increase in that bond, especially due in light of the fact that he already has a history for these kind of offenses. We are asking for that bond to be increased to a $10,000 surety bond. We are asking for $9,000 on the public indecency and $1,000 on the marijuana charge. Stay away from all MARTA stations, no alcohol, drugs, or weapons. Thank you.
All right, Ms. Holt.
Yes, Your Honor. Mr. Neese is 38 years old, Your Honor. He currently works remodeling houses. He's been doing that since his early 20s. So he's been doing that since he was 23. He's had a consistent job. I understand the history here some. However, timing on that history was not noted. And some of those charges are 20 years old, Your Honor, so they're not recent. So I do think the court should take all of that into account. Recent charges are criminal trespass, Your Honor, from 2022. He does have children, 3 children, 8, 4, and 3, as well as a mother that he lives with is 61 to 62 years old. And while he does have his own business, it is like anything else. He does have limited income, Your Honor. He has been in Georgia now for 10 years. He does have a GED as well. Right now, Your Honor, he has 2 charges, as you know, one being possession of marijuana. Okay, so to sit there and ask for any kind of significant bond on that particular charge, Your Honor, I find not to be, relevant or necessary, shall we say. I do not see that he is a danger to the community, and we do deny these allegations. So I do believe that a $3,000 bond on the public indecency charge and $500 on the marijuana charge is more than sufficient to assure that he shows up in court to address his issues.
Okay. I will go with I will order a surety bond. And I will order that in the amount of $4,000 for the first charge. That will be, I'm sorry, 3,500 is what I was going to do. 3,000 for the first charge and 500 for the second. I'm sorry, 3,500. Miss Bridgewater. I'm going to order no drugs, alcohol, or weapons while on bond. Stay away from 70 Hamilton A. Holmes Drive Northwest. And that's supposed to be the MARTA train station, is that correct?
That's
Yes,
correct.
Your Honor.
I won't ban him yet from all MARTA, but don't get a handle on things, then that's what'll eventually happen, I'm sure. Anything else?
Nothing from the defense, Your Honor.
Okay, was there any no further contact with the victim, or?
Your Honor,
I
based
didn't
on
write that down. I don't know if
right.
that's
I
correct.
did not have the victim's name from the warrant, and so I don't have a victim's name to provide the court. We're obviously waiting for the police report to fill us in on the individual. But I believe this was also based because MARTA does have a excellent camera system.
Yeah, well, I can put in there no further contact with the victim in this case without naming him
The
or
state
her.
would request no further contact from the victim, and we can provide that name hopefully in the next day or so.
Okay. All right, I'll add the no further contact with the victim. Anything else, counsel?
Nothing from the defense, Your Honor.
All right.
Yeah, Mr. Neese, if you have questions, I'll address them later.
No. You forgot to answer a question you told me earlier. You told me.
Okay, Mr. Neese, again, I'll address these later for you.
No. You need to ask the judge now, because you told me on that phone you was gonna ask the judge for a signature bond. You did not.
Okay, Mr. Neese, I'll address this later. Thank you.
I need to be here when you ask the judge for my signature bond, man. If you're gonna represent.
Okay, Your Honor, he is requesting a signature bond.
No,
And I was trying to remember, with the, history, ASG Fault.
Yes, Your Honor.
Your Honor, if you would prefer then, if you want to go for any lengthy into the history, then I do think we need a breakout room.
Okay,
And Your Honor, the state would object to a breakout. This is public information that's readily available. In fact, anybody can find it on the internet.
Yes, Your Honor. Like I said, just my request.
well, I don't know that I need to review it, since there is some history there, Mr. Neese, that's why I did not consider and deny the, signature bond. So I'm gonna stick to the surety bond for now. You can have that reviewed again on November the 8th, unless you bond out prior to that time. All right,
that's one more question, though.
quickly, short.
How can you take somebody's word over mine? Where's the camera?
Mr.
Not
Neese, I
taking
would
any
recommend
money.
again
Hey,
that
listen,
you,
hold up. You lied to me on the phone. You fired. I want to know the public defender, man. I don't need you represent me in my courtroom.
that's okay, but I would
You're
recommend
fired.
you've had your
You're not
hearing.
speaking to me no more because you lied to me.
All right, Mr. Neese, you will come back up on November the 8th unless you find out through bonding company for that $3,500 surety bond, okay?
All right, you're done. Position 17, Stewart. Stewart.
How you saying it?
Yes, Your Honor, I was not able, I was trying to call the courtroom to interview Mr. Stewart prior to now. So I will need to be able to interview Mr.
Oh.
Stewart.
You need a breakout, okay?
Yes.
PD Hoag, if I can ask, when do your cases start, just so we can make sure not to call your case up next?
Yeah, my cases, I think, started at 12.
Okay, so anything above position 12, got it.
Anything
Okay.
above position 12.
All right. Deputy, can we make that happen?
I have the cases in the South Annex, Your Honor.
Okay,
Good afternoon, Your Honor. This is position number 3 in front of you.
Hold on, South Annex, we still doing courtroom 2. We're not done.
all right. Go ahead, courtroom 2. You have another, who's that person there?
Position 17, Stewart.
Okay, courtroom 2, right now, Ms. Hoag needs to talk to one of the defendants, and that removes her positions because she can't talk to the defendant and present a case. Ms. Thomas does have cases, but they're all over at the South Annex.
Thank you, Ms. Hall.
So she can call there?
Yeah, can I call? That's fine.
Do you, I don't think you, let's see, I think we've taken, well, I don't know, unless you have 2 and 3. I was trying to see who else we had there that were above 12.
I have position number 3, Ms. Chisholm, who's in
Right.
South Annex.
And position number
Ready right
5.
now.
And she's on video, so the state's ready on that one.
We're
Okay.
ready.
All
with
right.
Ms.
All right, Deputy, we'll go to South Annex for position 3. This is
Hold on, Judge. Hope you could probably call 22392 or 22391. That's courtroom 2. All right, Judge, I'm ready. Sorry.
All right, this is 22 CR 0073336Y. And this is Charnel Chisholm, who charged with 1 count of battery family violence, 2nd count of cruelty to children in the 3rd degree. Actually 3 counts of cruelty to children in 3rd degree with the 1 battery family violence, all with the offense date of April the 20th, 2022. Pre-trial.
I got first arrest.
Okay. All right. Deputy Falk?
Yes, Your Honor. This incident happened April 20th, 2022 at 5098 Windsor Forest Lane in College Park at 7:52 a.m. Jontel Chisholm, and that's Jontelle. Last name same as the defendant's, stated that she and her sister, who's the defendant, had been working on an arrangement where Miss Jontel Chisholm would take the defendant's children to daycare and to school. Apparently, at some point, Miss Jontel Chisholm decided to discontinue that arrangement, stated she no longer wished to take the defendant's children to school. The defendant decided to drop her children off anyway at Miss Jontel Chisholm's door. Miss Jontel Chisholm then had AM, who's the minor child, call the defendant to let her know to come and pick up her children. The defendant arrived at the residence, began using profanity, and was led into the house by the minor child AM. At the point that she was led into the house, she struck Jontel Chisholm in the face multiple times, leaving visible marks and scratches. The children, there were three: DM, AM, and CC, who's the child of Miss Chisholm. Jontel Chisholm observed the defendant striking her in the face. We have had an opportunity to speak to Miss Jontel Chisholm. She stated that she and the defendant are sisters, that they have since made up. They are now on good terms. She stated she does not want to pursue these charges. However, and that the defendant does visit the residence often and helps with her children. Given those circumstances, Your Honor, given the fact that they are in fact sisters, and given the fact that this is the defendant's first arrest and she is, I believe, 31 years of age, the state is going to go outside of our normal recommendation and make a recommendation of a $6,000 signature bond through pretrial services. That's $3,000 on the battery, $1,000 on each of the cruelties, 1 day anger awareness, no further violent contact with Miss Jontel Chisholm, and no alcohol, drugs, or weapons.
All right. And Ms. Chisholm, do you wish to address the court today?
Yes, ma'am. I'm sorry. Yes, ma'am, I do.
Okay. Do you want to go first, Ms. Thomas, or you want the victim to go?
Ms. Chisholm can go first.
Okay.
Ms. Chisholm, excuse me.
Okay.
Yes.
Raise your
I wrote
right
it.
hand. Hold on. Raise your right hand for me, Ms. Chisholm. Do you affirm the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. All right. And tell me what you would like. Let me ask you first, are you in fear of Charnel Chisholm, that's your sister?
No, ma'am.
Okay. Anything else?
Yes, ma'am. I just wrote a brief little summary, if I could just say that.
Okay, let's see if it's brief.
Okay, I'm sorry.
People tell me that and it turns out not to be. So let's see how far we get, okay?
I do understand.
Okay.
Yes, ma'am. Okay. Good evening to everyone that is here today. Love you, sister. I'm sorry that we in court discussing our family business. We haven't had an issue of this nature since we were young girls, and I hate it came to this. We have since reconciled our differences on Father's Day and have been better than ever. We regret having to behave in a very terrible manner in front of the children, but we have reassured the children that we have put this behind us and is working to be better adults in their eyes and a stronger unit as a family. We've since been on 2 family trips and plenty of family outings in the city. My sister is her 4 children's sole provider, and she is needed by them. While she has been away, we have been taking care of her children, and has not been the easiest thing because these beautiful children miss their mommy. Though we cannot change the past, if I could, I would not have pressed charges, and we would have just given each other some time to fix our issue. Judge, my sister is needed home to her children. Whatever is decided for her today, we will get through it as a family, and I appreciate you for letting me speak today. Thank you so much.
Thank you. How old are the children?
12, 10, 2, and 1.
Okay. And so which 2 are all of those Miss Chisholm?
She said it wrong, but they are 12.
Miss Chisholm.
No. You're not to speak. I'm asking your sister, Jontel, which children belong to Charnel?
All four children belong. to
All
Ms.
four of
Chisholm.
her children? Okay,
Yes,
yeah.
ma'am.
okay. Thank you. All right, Ms. Thomas?
Thank you, Your Honor. Just to reiterate what's been stated, Ms. Chisholm desperately wishes to be reunited with her children. They are currently at her mother's home, or I believe with Ms. Jontel Chisholm currently right now. Ms. Chisholm is 31 years of age. She has been a Georgia resident all of her life. She is gainfully employed at Grady Hospital. She's the EVS technician. She was supposed to go to work yesterday. She works all this week. Fortunately, she was off today to, she's in an unfortunate situation and she's handling this matter, but she wishes to be able to get back to work. She does solely provide for her children. Her sister does assist her. Her mother does assist her. But again, she wishes to be back home with her children. Her children do reside with her. But again, her family does help with the children's care. Pre-trial did recommend her through for a signature bond. We are asking for the court to accept pretrial's recommendation and or the state's recommendation for the signature bond. Ms. Chisholm does not have any criminal history, specifically no violent history, Your Honor. So again, we are asking for the court to accept that recommendation and allow her to go home.
Okay.
And Your Honor, although there were 4 children, there were only 3 children who observed the incident, and that's AM, who at the time of the incident was 10 years of age, and DM, who at the time of the incident, it appears was 12 years of age. There's also a 3rd child, CC, who's the child of Miss Jontel Chisholm. I do not have an age as to that child.
Okay.
It's not my child. I'm sorry.
Mm-hmm.
It's Charnel's child.
My apologies. It was the same last name, so I wasn't sure. But yes, there is the 3rd child, CC, who apparently observed it and appears to be the defendant's child as well. So we only had 3 children that observed the incident.
Okay. All right, I'm going to grant the signature bond. And I'm going to grant that signature bond through pretrial. And the amount will be $2,000 on the first charge, which is the battery, and $1,000 on each of the cruelties. So that'll be a total of $5,000. And I'm going to order the one-day anger awareness course through pretrial. I'm going to order no drugs, alcohol, or weapons while on bond, except for anything prescribed to you. And I'm going to order no further violent contact with Jontel Chisholm, her sister. And I'm assuming everyone resides at the same location at the 5098 Windsor. Is that true?
No,
they do
according
not.
to the police report, they did not reside together at the time of the
They
incident.
do not live together, Your Honor.
They do not. So whose residence is the 5098 Windsor?
That is Miss Jontel Chisholm's address.
Okay. And so the state had requested to stay away from that address.
The
Is that
state
correct?
had not requested to stay away
Had
from that
not,
address, Your
okay.
Honor.
All right, so I will leave that off, but just no further violent contact. Can we do that, Miss Charnel?
Yes, ma'am.
Okay. All right, good luck to you, okay?
Next, we have position number 5, Your Honor.
Ms. Thomas, on number 5, are there any MH concerns? I
No.
was trying to figure out if we needed a breakout.
We do not.
Okay.
Thank you.
All right, this is case number CR 22 CR 0073333G. Kadara Durden. And I'm not for sure, sorry if I'm mispronouncing your name. You're charged with 1 count of pedestrian in the roadway and a 2nd count willful obstruction of a law enforcement officer, both with the offense date of October the 25th, 2022. Pre-trial.
8 total. She has a probation warrant out of card. She's on probation and card for theft by taking. Last arrest was 2021, terroristic threats. That's open in Fulton, 21 CP 197299. Step by taken, deception, I'm sorry. First offender for theft by taking over 2020 probation out of Clayton County. Deposit of account fraud, theft by taking conviction, 2019. 2015 probation for shoplifting. I think that's all.
Okay. Deputy Falk.
Yes, Your Honor. This happened October 25th, 2022, at around 2:30 a.m. Officers were called out to 7585 northbound expressway near 17th Street. They were called out there because the defendant was walking in the HOV lane. As the officer approached, the officer told her to move to the left shoulder of the highway. She refused to do so. The officer grabbed her and began to push her to the left shoulder of the highway because he didn't want her or him to get hit by a car. She began pulling away from the officer. At that point, she began swinging at the officer with an open hand. Several other officers responded to the location to block the highway because she then began running into the highway, into the second lane from the right side, and stood there with her arms outstretched, yelling for someone to hit her. At that point, a vehicle ended up having to stop in front of her suddenly. The defendant began banging on the window and was grabbing on the door handle. At the time, the officer then approached the defendant, tried to get her out of the roadway again. She refused to do so. He then advised her he was going to have to tase her. She did not leave the roadway, and he did in fact tase her and then place her into custody. So the current bond on this case is a $2,000 surety bond. The state does have some real concerns about this, given the facts of the case, given the fact that she was running out to the middle of 7585 at 2:30 in the morning. Quite frankly, I'm amazed that the Infiniti didn't just hit her, because cars go very fast down that expressway at that time of night. And so I think the officer was correct in being concerned for both his safety and hers. The state recommends keeping the bond as set, which is that $2,000 surety bond, $1,000 on the pedestrian in the roadway, $1,000 on the willful obstruction of an officer. I could say stay away from 7585, the stay away from the roadway, but I think that would be kind of nonsensical, being that it's an entire stretch of highway that extends down the road. So we're not going to ask for that. We're just going to ask for no alcohol, drugs, and weapons. And we would ask for a social worker to be sent out to meet with her, just because we do have some concerns based on her history, the fact that she is kind of collecting a history in a very short amount of time, as well as the charges and the current outstanding warrant she has from another county, which she's also being currently held on in the jail. Nothing further from the state.
All right. Ms. Thomas.
Thank you, Your Honor. I spoke with Ms. Durden. We are denying the narrative of these allegations, Your Honor. And we wasn't given that detailed report. According to the warrant that we did receive, Ms. Durden did not offer or do any violence to any officer. This is a nonviolent offenses. We are asking for a signature bond. Furthermore, we are asking for a signature bond so that she may be released to the Cobb County hold. I did speak with Ms. Durden about that hold. However, that was a violation due to some financial obligations in which Ms. Durden was unable to provide at this time. Ms. Durden is 27 years of age. She has been a Georgia resident all of her life. She does have family residing in Georgia as well, so she does have community ties. Ms. Durden completed her GED, and she's also employed with People Ready. It is a temp job, and her job does not start until Monday, so she does not have the financial means to make a $2,000 bond or any bond at this current time. I also did speak to Ms. Durden about any potential inmate concerns, in which she did inform me that she has none, and has no history of any. So that is not a concern for us at this time. However, Ms. Durden does wish to have any resources. She did not express that she needed any resources, but obviously our office will be able to assist her if she does need some. But at this time, Your Honor, we're asking for a signature bond so that she may be released to Cobb County and to deal with that matter.
Okay. State?
Your Honor, I also just want to point out that she's currently on a $7,500 good bond already for that theft by deception case under 21 CP 197299, which is also a reason the state asked for a surety bond.
Okay. I'm going to order a signature bond in the amount of, let's see, on the first charge, I believe it was 1,000. And on the second, well, I think each charge was $1,000. So I'll do the $2,000 signature bond through pretrial.
Yeah, she got a hold.
Well, so that she can go to Cobb, I guess. So you all would just have it through the jail so she can go to Cobb?
Correct.
Okay. And I was thinking it as I was saying it, so that'll be through the jail. But to be released to Cobb County only. If we have the availability, Ms. Thomas, can you have social services to speak with her?
Yes, Your Honor. I can try to get someone down there to speak with Ms. Durden if she likes, prior to her being transported to Cobb County. I'm not sure how soon Cobb County would pick her up, so I can get someone down there as soon as possible.
Okay. I know, and I don't know how to say stay off the highway, but I guess we can kind of say that a little bit.
State's not going to ask for a stay away, but we are going to ask for no alcohol, drugs, or weapons.
No drugs, alcohol, or weapons.
And maybe we can ask, do not walk upon the highway. So she wants to drive, that's fine, but just don't walk on the highway.
For your own safety, Ms. Durden, we're gonna put in your bond that you will not walk or in the middle of any roads, any highways. Be careful, take care of yourself, okay?
Yes, ma'am.
All right, good luck to you.
That'll be all for South Annex, Your Honor. May we be excused?
Yes, you may. Have a good one.
Thank you.
We got position 7 and 8 taken, please.
Yes, Your Honor, and those two positions are pro se.
Wow, who's doing the paperwork?
I believe they had the paperwork down there in courtroom 2.
Your Honor, I sent the paperwork to Miss Bridgewater and Miss Grace, but I may have needed to.
I have the paperwork.
Oh, okay. I just wanted to make sure someone had it. I did go ahead and forward
Yes.
that paperwork, the complete.
I have it.
Has it been completed?
I believe it has. Give me
Oh.
just,
We did receive it from Mr. Norris. And
it has been completed. We're ready to go.
Oh, wow, I'm excited.
So am I.
And is that who we had before us, Mr. Griffin?
This is Mr. Jenkins.
I mean, I'm sorry, Mr. Jenkins.
8.
8 and 9. No, he's just position 8. I thought there were 2. Oh,
there
but
are
same
position
person.
8 and
I
9,
got
but we can start with Mr. Jenkins.
Yes, that is correct.
I was thinking it was the same person. All right, Mr. Jenkins, this is 22 CR 0073337E. Damian Jenkins, you charge at 1 count of criminal trespass. The offense date is August the 25th, 2022. And I understand that you wish to take a plea today. Can't hear you. There's some background noise.
Oh, yes, ma'am. Yes, ma'am.
Okay. And so you wish to represent yourself,
Yes, ma'am. Yes, ma'am.
and you understand the consequences of that. You're to know the laws. You can't practice law and help you, but you're gonna take the plea on your own. Is that correct?
Yes, ma'am. Yes, ma'am.
I'm gonna ask you a few questions before taking your plea, okay?
Okay.
All right, so it's my understanding that you wish to take a plea today to the 1 count of criminal trespass. Is that correct?
Yes, ma'am.
I want to ask you a few questions. Are you presently under the influence of any medications, drugs, or alcohol at this time?
No, ma'am.
All right, and do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that by pleading guilty, you are giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Do you understand that by pleading guilty, you will not be able to confront your accusers and all the witnesses that will be called to testify against you? You will not have that option.
Okay.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes.
Huh?
Yes, ma'am.
Have they promised you something for pleading guilty?
No, no, ma'am.
Okay, all right. And let me also ask you, do you understand that if you're currently on probation, your probation may be affected or revoked because of your guilty plea here today?
Yes, ma'am.
All right, and do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And I forgot to ask the state what were the conditions for the plea. So let me ask Deputy Falk that.
Your Honor, the state's recommendation was 12 months probation, 1 day in jail, release time served, balance suspended, stay away from Publix located at 2020 Howell Mill Road, Atlanta, Georgia. This happened yesterday. The defendant went on the premises to fill up an empty water bottle after he'd been told to stay away from that location.
All right, so you understand those conditions is that you must stay away from that Publix at 2020 Howell Mill Road. Can you do that?
Yes, ma'am.
Okay, I'm trusting that you will. You're not to go back there, else you'll end up right back here. Understand that?
Yes, ma'am.
All right, I'm going to accept your guilty plea. And that's 12 months to serve, 1 day credit for time served, and a stay away from the Publix. There's no other conditions. Is that correct, Deputy Falk?
Your Honor, the probation balance is suspended upon the entry of this plea, so he will not be on active probation.
Oh, you will not. Okay, probation is suspended. Okay, so you will not. All right, is that your understanding of the plea, Mr. Jenkins?
Yes, ma'am.
Okay, all right, I will accept your plea. And good luck to you, and stay away from Publix, okay?
Yes, ma'am.
So we have all the paperwork, Ms. Bridgewater?
We do.
Okay, great. All right, that will conclude your case, Mr. Jenkins.
All right, thank you, man. Have a nice day.
All right, you too.
This is position 7, Griffin.
All right, this is case number 22 CR 007335J. John Matthew Griffin, you're charged with 1 count of theft by shoplifting. You understand that you wish to take a plea today?
Yes, ma'am.
And you're going to be representing yourself?
Yes.
All right, let me swear you in. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, and you understand the consequences of representing yourself. We can't give you advice, but you're choosing to go forward anyway. Is that correct?
Yes.
All right, state, what is the plea?
State's recommendation is to this one is 12 months probation, 1 day in jail, release time served, balance suspended, that the defendant take an anti-theft course and stay away from the location of GameStop located at 11720 Medlock Bridge Road.
Okay. Is that your understanding of the plea, Mr. Griffin?
Yes, ma'am.
And Your Honor, my apologies, just briefly facts of this case, the defendant entered that location and took 3 game controllers from that location and walked out with them, which is the basis, and walked past all points of sale, which is the basis of this charge.
Okay, thank you. All right, I'm going to ask you a series of questions as well, Mr. Griffin, to make sure that you understand your plea.
Yes.
And so I need to ask you, are you currently under the influence of any medication, drugs, or alcohol?
I'm not.
All right, and do you understand that by pleading guilty today, you're giving up or waiving the right to the presumption of innocence?
Yes, I do.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you also understand, or has anyone promised you anything to plead guilty today?
No.
Or did anyone told you that you would get a lesser sentence for pleading guilty today?
No.
And you also understand that if you're currently on probation, that your probation may be affected or revoked because of your guilty plea here today?
Yes, I do.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
So as to the charge of theft by shoplifting, how do you plead?
Guilty.
All right, and the conditions are 12 months probation, credit for time served 1 day, balance will be suspended, and you're to take the anti-theft class, and you're to stay away from the GameStop at 1120 Medlock Bridge Road. Is that the correct address?
I have, and I may not have heard your honor, 11-720.
Oh, I didn't have that correct. I'm sorry, 11720
Yes,
Medlock Bridge Road. So you understand, Mr. Griffin, you're not to go back there, else you'll be immediately arrested.
Yes, ma'am.
Okay, all right, but you've got to get the information and take that anti-theft class before you will have your probation suspended. Is that understood?
Yes, ma'am.
Okay, all right, I will accept your plea and good luck to you.
Okay, thank you.
All right, you're welcome.
Come on, Mr. Stewart, position 17, Stewart.
This is 22 CR 007345G. Christopher Stewart, you're charged with 1 count of loitering or prowling. The offense date is October the 25th, 2022. Pretrial?
Second arrest. He had a DUI in 2014. It was a minute to reckless driving. That's it.
All right,
I didn't do a recommendation. I'll leave that up to you.
okay. All right. Deputy Falk?
yes, your honor. I think the reason that pretrial may not have made a recommendation on this one is because this occurred at 7:30 p.m. Yesterday at 3655 Mayfair Road. The defendant was actually going door to door, checking other people's backyards and looking under their floor mats for keys to enter their homes. The officers then questioned him about why he was at that location. He stated his vehicle didn't have any gas and he needed help. And then the officers asked if they could have permission to start his vehicle, which they did, and it showed that he had a full tank of gas. So that version of events that he gave of not having any gas kind of, ran out of steam at that point. He was taken into custody. There is currently a $1,000 surety bond on this one. We are asking that it be increased to $2,500. I know he does not have much of a record, but the state has some real serious concerns about someone walking around at 7:30 at night in a residential neighborhood, trying people's doors and looking under their mats for keys. And for those reasons, we are asking for that $2,500 surety bond. Stay away from the from the 3000 block of Mayfair Road. No alcohol, drugs, or weapons. Thank you.
Okay,
Yes, Your Honor. Mr. Stewart is 33 years old, Your Honor, and he's been in Atlanta, Georgia for the last 10 years. He does have a high school education as well as some college. He came here to help his grandmother and cared for his grandmother for a number of years who had pulmonary embolism. She did pass away about 6 months ago, and since then he's had a job doing DoorDash, Your Honor. I actually have that he was approved for a pretrial release. That's what I've got in my thing, Christopher Stewart, but maybe I have that wrong. But given his lack of criminal history, that all he has is a 2014, which is now 8 years old, DUI that was reduced to reckless, Your Honor. I do believe that that particular a pretrial or signature bond is justified in this case. As far as the facts of this case, he soundly denies them. And like any other police report that I've ever read, quite frankly, it's a police report, it's hearsay. He is innocent until proven guilty, and I would like to see something a little bit more than what's in a police report before I just take away someone's right to someone's ability to have a signature bond who has absolutely no criminal history. He's been charged with loitering, Your Honor. So like I said, I believe that given his lack of criminal history, the only thing he has is a DUI. There's no violence, there's no burglary, there's no theft, there's no anything. He's 33 years old. I do believe a signature bond in this case is justified. Otherwise, I would go for the lowest bond possible, the $500 surety bond.
okay. I'm going to order a $2,000 signature bond through pretrial. No drugs, alcohol, or weapons while on bond. I'm going to order stay away from the address again.
We would ask for a stay away from the 3000 block of Mayfair.
Okay.
And that is Mayfair Road in Atlanta.
Okay, so stay away from that whole block on Mayfair Road. I'm assuming he does not live over there.
No, Your Honor, he does DoorDash, so I imagine that he'll have to then just deal with the fact that he couldn't deliver to that block.
Right, make sure you stay off of that block, Mr. Stewart, while you're on signature bond, okay? And no drugs, alcohol, or weapons while on bond, except for anything prescribed to you. And I think that is all that we have for this case. Anything else, counsel?
Nothing for the
this
defense,
date.
Your Honor.
Thank you.
All right,
Thank you.
position 12, Morris. You got it.
This is 22 CR 007342D, Jonathan Morris. You're charged with 1 count of disorderly conduct. The offense date is 10/25/2022. Pretrial,
Yeah, 41 total.
41.
Correct. This is the first Georgia arrest. The rest come out of Florida. He's a resident of Castleberry, Florida. Last arrest was back in May. It says moving traffic violation. Like driving while license suspended or revoked. 2021 disorderly conduct conviction. 2021 public order crime conviction. Also 2021, it says threat, death, or serious harm. I guess that's like terroristic
threats.
Yeah, that was a conviction. 2019 disorderly conduct conviction. 2019 FTA battery. Carrying concealed weapon. That was from 2019. No, 2018 actually. Disorderly conduct with that as well. 2017 battery, touch, or strike. Charges were dropped in that case. He had a perjury. It says making false affidavit. That was 2013. I got 2012 trespass to a structure conviction. Also false imprisonment, battery convictions. I think I stopped there. 2011 false fraud impersonation, giving false information to police. Petty theft, first offense. 2010, he had obstruction from 07. That's it.
All right. Deputy Falk?
Yes, Your Honor. This happened October 25th, 2022 at 5:23 p.m. Officers were standing at the entrance of the MARTA station at 30 Alabama Street Southwest in Atlanta, Georgia. The defendant walked up to Officer Smith, started throwing up hand signs, which according to the officer's knowledge and experience, he believed to be gang signs for the Crip organization. At that point, the defendant was told his behavior was inappropriate, and he then proceeded to enter the station, and the officer returned to his post. While walking away, the defendant stated, "Fuck out of here." The officer continued to try to ignore the defendant's behavior. At that point, the defendant continued to walk back and forth in front of the front gate. The officer asked if he needed any assistance. The defendant stated, "I don't need shit from you." And then the officer at that point, I think, just kind of got a little fed up, told him he was being disorderly, and instructed him off the property. While the defendant was walking off the property, he said, "Don't be here when I get back," to the officers, at which point he was placed under arrest. The state's recommendation is a $1,500 surety bond on this offense. I understand the bond is currently at $600. I understand that this is a disorderly conduct charge. However, we are taking into account the defendant's lengthy history. I know the defense hates when I say this, but he has as many cycles as he's been on this earth. And so our concerns are that he has cycles for disorderly, terroristic threats, criminal trespass, all out of Florida. So not only is he not a resident of this state, his address is a Florida address, but he also has a lengthy history of the same type of conduct. And for those reasons, we are asking for a $1,500 surety bond, that the defendant stay away from the Alabama Street MARTA station, and no alcohol, drugs, or weapons. That's all.
All right. Ms. Cole?
Yes, Your Honor. Mr. Morris is 40 years old, Your Honor. He has a high school degree as well as some college at Seminole State. He's also currently attending Seminole State. He's looking to get his degree in business. Right now, he has his own company. It's JDSM Logistics. It is a home moving, setting up company. So he does do business here in Georgia, Your Honor. So, and he intends to continue to do business here in Georgia. So even though he does have a Florida residence, which is not the first person we have here who has it out of state, he does business here, intends to continue to do business here, and so is definitely interested in making sure that this does get resolved, Your Honor. He's not going to not return because he has financial ties here that are very important to him. As far as his history goes, yes, he obviously does have some history there. All of it seemed to be pretty much disorderly conduct. My understanding here in reading the report, which I think is also very important, is he did not actually approach the MARTA person. He was, I guess, acting somewhat angry because he was not able to get his ticket to work through the gate. And the MARTA person looked over, thought that he was staring at them. I'm not sure where the gang sign's coming from, having done gang work and having have everything be a gang symbol to a lot of officers. But he has no gang history, so I think whatever it was misinterpreted. And then, as I said, Your Honor, he was escorted off, and while he may not have been pleasant while being escorted off, as far as I know, he didn't try to attempt to swing at anybody. He did not walk up to the MARTA personnel. The personnel walked up to him. And so while his conduct might not have been as nice as it could have been, Your Honor, other than some choice words and a bit of, just frustration not being able to get through the gate, that was the extent of his disorderly conduct at this time. I do believe that a signature bond is warranted in this case, that even though he does have a history, the facts of this just really don't rise to a level of requiring a surety bond. But if so, then we request the lowest surety bond possible of $500.
And Your Honor, the state did misstate, and I do want to correct myself. Thank you, Ms. Hoag. He was staring at the officer while holding up the sign, and at that point, the officer did approach. So the defendant did not approach initially. It was the officer who approached after seeing the defendant staring at him and holding up the gang sign.
Like I said, Your Honor, I would question the gang sign.
Okay. I'm going to go ahead and continue with the surety bond in the amount of $1,000. No drugs, alcohol, or weapons while on bond. And a stay away from the MARTA at 5 points, I believe that is at 30 Alabama Street.
Yes, I think that's correct.
So stay away from there, Mr. Morris, while you're on bond. Be careful. No drugs, alcohol, or weapons while on bond. And I think that's it, unless council has anything else they want to take up.
Your Honor, I do need to address with this court. My company is due to depart on Friday. I am a guest here staying at a motel while I was working. Because of the way the detention works here, they have not even provided me my cell phone in my property. So I don't even have any phone numbers to call anybody for bonding out. I have no immediate family in the area because I was only up here for a week or two for work. Any of my prior issues, I've never had an issue reporting back for court. As a matter of fact, I do have an open case right now in
Okay,
Central Florida.
Mr. Morris,
Pre-trial where I'm out on bond as we speak.
Mr. Morris, we'll address that. As I told you, we'll address your issues with being able to contact someone.
Because you're indicating it requires a signature and I don't have an ability to contact anybody. My phone's not even in my possession to retain any phone numbers. I don't have any immediate friends or family up here because I'm up here on business. So I'm going to be left stuck here in jail. It's already predetermined based on those factors. You're leaving me stuck here in jail now. I have no immediate friends or family or even the ability to contact them. I don't even have my phone and my property to retain any contacts.
All right, well, you do have a low bond, a low surety bond. And with the number of cycles that you have out of Florida, down to Georgia, I cannot give you, do not see a signature bond at this time.
So does a surety bond allow me to pay the bond in its entirety on my own accord, or does it require a bond?
No, Mr. Morris, we'll discuss this, but you can pay it on
I'd
your
like
own
to
accord.
get it out of the way. I'd like to know if I can walk into this booking, if I can pay the entire amount, if I can be removed from him. That's what I'm trying to get.
Yes, Mr. As I said,
Surety bond.
Mr. Morris, you can pay the bond directly. You do not have to go through a surety company.
So I can pay the bond in its entirety and I'll be released on my own accord to report back here for further court appearances.
Yes, you can.
And that is excusable in this particular county because it's not excusable in every county, in every district.
As I said, Mr. Morris, you can pay the bond.
Okay. On my own, because
We're gonna explain it to you.
Mr. Morris, I think we need to pick this up later.
Okay.
So I think we need to move on.
Mr.
I
Morris,
don't have anybody to
Mr. Morris,
contact on business, nor do I even have my phone.
Mr. Morris.
Mr. Morris, this is not your time to speak with your attorney.
Okay.
She will give you a call, or you can give her a call after court and go over the specifics. Right now, we have to move on to other cases, okay?
2 weeks.
The exact date, my exact date, my exact next court date.
If you don't bond out before the next court date, it will be November the 8th.
Okay, thank you.
All right.
15, Ridley.
I'm sorry, Deputy.
Position 15, Ridley.
Oh, okay.
How you doing?
And Your Honor, I requested a conflict attorney, but no conflict attorney was assigned.
Uh-oh.
He wants to pro se.
Oh, okay. Well,
Okay, let me call this case. It is 22 CR 007349Y. State versus Starlin Ridley. You're charged with 1 count of simple battery and the violence. The offense date is October 25th, 2022. You wish to represent yourself, Mr. Ridley?
Yes, I do.
Sorry?
Yes, I do. Yes, Your Honor.
Okay, do you understand the consequences of representing yourself?
Yes, I do. I have a good look.
All right, you're supposed to know all the laws and
Yes, I do.
hopefully represent yourself in a good manner. So we'll see what happens, okay?
Yes, I do. Yes, Your Honor.
All right, pre-trial.
7 total. Last arrest was 2018, sale of marijuana, sale of meth. He got a conditional discharge. That was out of Gwinnett County. Before that, 2011 trespass, misdemeanor possession of marijuana. 3 counts of contributing to delinquency of a minor. And he was arrested in Alabama. Last arrest there was 03 marijuana, 03 marijuana and weapons, and ag assault domestic from 01. That's it.
All right. Deputy Falk.
Yes, Your Honor. This happened yesterday at 1:18 a.m. At 994 Catherwood, that is KATHERWOOD Drive. Officer spoke to Ms. Tara Winkfield, who has lived with the defendant at that address for 5 years. Ms. Winkfield stated that the defendant struck her on the arm with a stick. We have had an opportunity to speak with Ms. Winkfield. She stated, and that is WINKFIELD. First name Tara, common spelling TARA. We have spoken to Ms. Winkfield. She stated that they were in a relationship. It is ended as a result of this incident. They are living together and they do share no children. Ms. Winkfield further stated she wants no contact with the defendant and she wants him to stay away from the address at Catherwood Drive. We also will need a one-time law enforcement escort for the defendant to retrieve his belongings. And Ms. Winkfield stated this is not the first time there has been an incident between the two of them. I will point out that the BGCSA for meth case that he is currently on conditional discharge, we actually showed it was out of Clayton. And I did look up the case and show that it shows that he has a probation violation that was issued April 21st of 2021 by Judge Fluker. It does not appear that that has been resolved at this point. We also have some concerns because of the history out of state, as well as that, granted it is old, but a 2001 assault case involving violence to another. So for those reasons, we are asking for $3,000 surety bond, no further contact with Tara Winkfield, stay away from 994 Catherwood Drive, a one-time law enforcement escort for his belongings, and no alcohol, drugs, or weapons. Thank you.
Now can I talk since I represent myself?
Well, you don't cross-examine the state. It would be if there was a witness or something, and I don't think we have any witnesses or victims regarding your case on the Zoom call, do we?
Yeah, you have a video camera on your office. Yes, that report y'all have right there, everything is false. I went to subpoena the video evidence, and that's what I want to subpoena, because all of it is false, and I want you to watch it. That's what I do, because y'all have been bamboozled. The whole report is false, because they came for a lockout. That's what they came for. They didn't come for anybody being hit with no stick. And also, they have been there a whole hour and a half. When they find out the lockout wasn't the reason, that's all she had to do is reach in the door and open the door, right? And I was talking to Officer A. Williams, right? She was telling me to explain the incident, right? And I was telling her that she wasn't being locked out. She was asking, did she call the police from, you know, how you don't know that she called the police? I had fixed some chicken and went back and went to sleep. She has a severe depression problem and she been drinking. She have 50 cases where she have called y'all on a false report where she drinks and she don't take her medicine. Do you get me? And I'm the one that feed her and make sure she take her medicine. If you're drinking, you're not taking your medicine. Look through the 911 calls, and she have about 50 or maybe 75 calls where she done said somebody done hit her. She had one yesterday that on a 911 call, and she said somebody hit her, and she was terribly drinking. She was intoxicated. I don't drink, ma'am. You do get? She was intoxicated. I asked the police, let me blow in the breathalyzer to show you that I'm not drunk. They didn't do that. And it said, man, your breath, I smell it on your breath, sit right here. We have, hold on, we have went, and the officer, as I was explaining, she said, you don't know like you're dumb. I said, like I'm dumb. I have a criminal justice degree. You cannot verbally assault me. And I was explaining what was happening. So I said, okay, hold on. Let me, hold on. You said recording stop. But what I'm saying,
Judge, check your chat, please.
okay. Now, he called me dumb, so I asked for a higher power. I said, call your superior. Do you get me? And she was like, if it was all this is on video and tape, audio.
Yeah, but this is not your trial. Hold on a second. This is not your trial. This is just a bond hearing.
And it takes back.
You know whether you're gonna.
Ain't nobody seen nothing back to an hour and a half later when she walked in the house. She walked in the house and said, grab the stick and hand it to the officer and said, he hit me with the stick. And then they put me under detain. Oh, sir, put your hands behind your back. This is an hour and a half. Do you get me? There's no evidence of being hit nowhere with the stick.
Okay, but like I said, I am not here
I'm just
to
saying.
determine the evidence. You've already been arrested because of those allegations. So what I am determining is certain factors regarding your bond and returning to court and making sure that happens.
I want the video looked at. I want the audio looked at because I'm going to turn on fair on.
Well, that will happen. That will happen at your trial.
Yes. I'm sorry.
Not at the forum.
I'm sorry, but I want the phone looked at.
Eventually, there will be.
Yes. Because all of it is on audio and video. I know y'all trying to connect the past with the present, but I have no outstanding warrants or nothing. And all that has been resolved.
Well,
Yep.
what I'm going to do is to give you a surety bond. I think it's recommended for a $3,000 surety bond. And so you can go through a bonding company, or if you have the money yourself. No drugs, alcohol, or weapons while on bond.
I'm gonna stay right here and line it out.
And
Yes.
we're going to also order that you stay away from the address on Catherwood Drive. You don't reside there, is that correct?
I do. I've been there 5 years.
Is it a rental or is it a purchase?
Everything in the house is mine. I've been there 5 years.
Well, we have a victim, was Winkfield. She's residing there as well, correct?
Yes. And she.
Well, what I'm gonna do right now, so that there's a proper cooling off period, I'm gonna ask you to go stay somewhere else.
Okay.
If you get out, yeah, and go stay somewhere else.
She had a protective order on the pill because this mental health thing. She had a protective order on the fifth that if she didn't go to, she could have got me evicted and everything out of there. She didn't go to it because she's back and forth. But you know, I just don't, I just don't get it. Every time she drinks, she calls the police all of a sudden.
Okay, well, that's what you would bring up at trial. I'm gonna stop you, I'm gonna cut you off. You're bringing up things that will be addressed at the trial. This is not your trial today. I have given my ruling, $3,000 surety bond, no drugs, alcohol, or weapons while on bond. Stay away from Miss Tara Winkfield. And I'm sorry, no further contact with her, and stay away from the Catherwood address, okay? That would be my ruling for today.
Okay. And when can I know anything back from that video? But I want the whole video.
You said you want to mail something back?
I want to watch the whole video.
When you get out, you can go by the solicitor's office possibly.
I want the whole video.
When you get out, and
Right.
speak to whoever's assigned to your case.
Because you have officers in here that's not doing their job and they're putting charges on people and it's on video. And I have a criminal justice degree, I know what's right, and wrong.
Okay,
Right. And I'm gonna.
all right.
I'm gonna-
We're gonna end this because all the other things that you're talking about, I'm not able to address.
Okay, go ahead and have a seat over there for
I'm
me.
gonna expose that. though.
Position 6, Partech, come on.
Thank you. I'm gonna expose that officer. That's what I do. Hey, William.
All right, this is case number 22 CR 0073334D. Nicholas, is it Furtick? Sorry if I mispronounced your name. You're charged with 1 count of battery family violence, 2nd count of cruelty to the children in 3rd degree, 3rd count of criminal trespass and damage to property, and a 4th count of obstruction of law enforcement. The offense date is July 3rd, 2022.
11 total. Address shows the resident of Orangeburg, South Carolina. He got an open case in state court, simple assault, family violence. 22 CR 001-810 D as in David. He also may have open disorderly conduct. He's on probation in Douglas County for criminal trespass. They gave him 12 months probation back in July. He had a 2020 criminal damage to property. He was amended to trespass. Got history out of state. I got a 2010 out of Florida for giving false name. That was dismissed. 2010 South Carolina, common law robbery, strong arm robbery conviction. 2012 defrauding a hotel, boarding house, or a restaurant. 2012 driving without a valid license, giving false name, violation of probation. The giving false name was a conviction. 2013 burglary, 2nd degree, possession of a weapon during a violent crime. Those were convictions.
You assign me that phone over there.
And 2014 armed robbery with a deadly weapon, burglary and possession of a weapon.
Are you going home?
Yes, I am. That's it. I think the 2014 was him being sentenced, I think, for those charges. That's all.
Okay. All right, Deputy Falk.
Yes, Your Honor. This incident happened July 3rd, 2022 at 1212 Utoy Springs Road, Southwest, apartment 13. Officers had gone out to that location actually 2 times in the same day. So this is all part of one incident. The first time they went out, they spoke to Miss Tyriqua Walden, that is TYRICQUA, Walden, WALDON. And she stated that the defendant, her ex-boyfriend, they were in a verbal argument over text messages that the defendant had on his phone. The defendant then damaged her Nissan Altima by slashing a tire and shattering items inside of the apartment. Officers were called back later to that location because the defendant was actually not present at that time. Officers were called back out to the location later in the day and could hear a verbal dispute inside the apartment. When they were finally able to get Miss Walden to come to the door, she stated the defendant had come back to the apartment and a verbal dispute began again. That the defendant then got upset because she called the police the first time and stated he had just gotten out on bond. She stated he then struck her in the leg with a broom, dragged her into the bathroom while repeatedly striking her in the head. He stated he then dragged her into the living room where NW, their juvenile son, was playing a game. The defendant threw her against a wall multiple times as she was trying to run out of the door. Miss Walden at one point secretly texted 911. And at that point, the officers were dispatched out. When the officers arrived, the defendant then jumped off a 2nd-story balcony. The officers did have an opportunity to interview NW, the juvenile, who stated that he saw the defendant strike and throw his mother several times, and also saw the defendant jump off the 2nd-story balcony when the police were at the door. So here's the problem with this particular case. This defendant has a history when it comes to Miss Walden, and that history is a violent one. So we already have this 22 CR 001810D case that's currently open in state court that alleges a simple assault and a criminal trespass. And that stems from an incident that happened between these two parties where back in March of 2022, the defendant, grabbed a chair during a verbal argument, raised it as if he were going to strike her, and then struck multiple items in the residence which the officers saw were destroyed. At that point, the defendant was given a $2,000 surety bond. The breakdown on that was $1,500 on the simple assault, $500 on the criminal trespass. He was ordered to stay away from 1212 Utoy Springs Road, which is the same address he went back to in this case. He was also ordered to have no further contact with Miss Walden, which he clearly had contact, and that was signed by Judge Williams on March 30th, 2022. The defendant was then released on April 4th of 2022. Additionally, the defendant's July 2022 conviction for criminal trespass out of Douglas County again involved Miss Walden. In that case, he was sentenced and given 12 months probation, no further violent contact with Miss Walden. And we are also showing an FTA stemming from October of 2022 from our 2022 CR 001810D case. So he's actually got a current FTA pending from October of this year for that case where he did not appear for court as ordered. He also has that violent offense in 2014, that conviction out of South Carolina for armed robbery and aggravated assault. All this adds up to a situation that, quite frankly, Your Honor, is a powder keg, and we are very concerned for the safety of the victim in this case. We have had an opportunity to speak with her. She stated she does not want to proceed because it's causing a strain on their relationship. She also stated that she was not aware of the fact that the defendant had a no contact order. However, it's irrelevant whether she was aware of it, because the defendant was aware of it when he was ordered to have no contact with her back in March by Judge Williams. And she also stated that the defendant reached out to her yesterday after his arrest from jail, again, violating a no further contact order. I'm not sure how many times we can say he is to have no further contact with Miss Walden. The state recommends a $4,000 cash bond on this case, Your Honor, $2,000 for the battery, $1,000 for the cruelty to children, for having their minor child watch him as he beat his mother, and $500 for the obstruction and the criminal trespass. We're also asking for a stay away again from 1212 Utoy Springs Road, Southwest, and no further contact again with Tyreka Walden. That's all for the state, Your Honor.
Okay, Ms. Thomas.
Thank you, Your Honor. Mr. Furtick is strongly denying these allegations, and we would like to remind the court that these are allegations. Mr. Furtick has not been convicted of these charges. Mr. Furtick is 31 years of age. He has been a Georgia resident for the past few years. Mr. Furtick did express that he just started working. He was able to obtain employment at McDonald's and the Wendy's, and he does not wish to lose those jobs. He would not be financially capable of paying a high bond, surely not a cash bond, Your Honor. Any bond at this time is essentially going to be a no bond for him. I did also reach out to Miss Walden, who did express to me that she is not in fear of Mr. Furtick, and that he did not have anywhere else to go, and that she did not have an issue with him coming back. As far as the FTA, Your Honor, the notice for court did go to Miss Walden's residence, in which Mr. Furtick had not been there. So that is why he does have the FTA. I did advise Mr. Furtick that he would need to update his address. At this time, we are not opposed to a stay away, or obviously not opposed to a no contact. However, we would be asking for him to be allowed to get the remaining belongings with law enforcement, Your Honor. But as far as bonds, again, Mr. Furtick is not going to be able to make a high bond. We are asking for a surety bond in the amount of no more than $3,000.
Okay.
And I believe that would make his bond, if granted a surety bond, because he has a $4,000 surety bond for the FTA. So we would be asking for the surety bond, Your Honor, to give him that opportunity to maybe go through a bonding company.
Okay. Well, I think what I'm going to do, with Mr. Furtick is do the, surety bond. And I think that, let's see. 2,000 on the battery, 1,000 on the cruelty, 500 on the other two, obstruction and criminal trespass. So that's a total of $4,000. Making sure my math is correct.
That's
Yeah, that's
correct.
correct.
All right. So $4,000 surety bond. No drugs, alcohol, or weapons while on bond. And a stay away from the, is it 1212 Utoy Springs Road?
That's correct.
Jean?
That is correct, Your Honor.
All right, and no further contact with, and did y'all hear you say Tarika? I may be mispronouncing her name. Tarika. Mm-hmm. Okay. And no drugs, alcohol, or weapons while on bond. And then I guess we have to also stay away from the juvenile MW, correct?
Yes, Your Honor. The
Yes.
state is making that request.
Okay. Anything else, counsel?
Position 16, Rogers.
Excuse me, Judge. Let me ask one thing.
Yes.
Does he have a one-time escort?
Oh, yes, he did ask for that. Yeah, the one-time law enforcement escort to return to the property to get any personal belongings. Yes. Thank you for reminding me.
Nothing further, Your Honor. Thank you.
All right, thank you.
16, Rogers.
Okay. This is position 1622 CR 007346D Rico Rogers. You're charged with 1 count criminal trespass. The offense date is 10/25/2022. Pretrial.
14 total. Last arrest was March 2020. 2 counts of ag assault, possession of a firearm during the commission. He's on probation for that. 20 SC 176925. Also on probation for another ag assault. 19 SC 166264. 2019 failure to appear for robbery. 2019 probation, some weird charge. 2019 simple battery conviction. 2018 reckless conduct. I think it was amended to disorderly conduct. That was a conviction. Another 2018 probation, 2016 probation. I'll put that in the chat.
Okay.
Shelly, I'm done.
All right.
Okay, I wasn't sure. Thank you. So this state's recommendation on this case is going to be $1,000 surety bond. This incident happened October 25th at 4 p.m. The defendant actually changed the locks at Heritage Square Apartments at 350 Lanier Street, Lanier, apartment D4. The defendant was evicted from that location and told not to go into the apartment, and he was coming out of the apartment when the officers encountered him. He had changed the locks and had a key in his pocket. When asked, the defendant did state on police video that he does remember being told not to go back into the apartment. Based on his history, that is why the state is asking for $1,000 surety bond, and no further, stay away from the Heritage Square Apartments located at 350 Lanier Street in Atlanta, Georgia. Thank you. And no alcohol, drugs, and weapons. Excuse me.
All right.
Thank you.
Okay. All right, Ms. Holt.
Yes, Your Honor. Mr. Rogers is 26 years old. He is a lifelong resident of Georgia. He has family out in Douglasville where he was staying, so he does have a consistent resident, as well as family there, a cousin and an aunt, along with other cousins and other aunts in the state, Your Honor. So he is not a flight risk, and he will be showing up to court. He was coming into Atlanta to try and find a better set of work in the Douglasville. He was doing several jobs, working for stocking supplies at a gas station and a tire company, washing cars, all of that. So he was trying to come here to find better work. He does have a GED. He does definitely deny changing the locks on this. There is no proof that he did. He does say that he was given the key by a friend and that he was staying there and that's why he was there. Your Honor, given that this is just a staying in an empty apartment, Your Honor, he was not acting unruly, was not doing anything other than staying in a place that was empty. Your Honor, so I do believe that even though he does have a history, that a signature bond would not be unwarranted. Otherwise, we're asking for the lowest bond possible of a $500 good bond. But we do believe that given this financial situation, any bond is going to be difficult to make. So a signature bond would be greatly appreciated.
All right, I'm going to order the $1,000 surety bond. I'm going to order a stay away from the Heritage Square apartments, which are on Lanier Street. Don't go back to that complex at all. I'm assuming you don't live there, do you, Mr. Rogers, because you don't have a key. So you're not to go back there, else you'll be back down here in jail.
And Your Honor, he was evicted from that location, so he does not live there.
Right.
No, I don't believe he was evicted, but I don't believe he had the actual, to be evicted, he would have to have been there paying rent. But I do believe that he was told he could stay there. And Mr. Rogers, please remain silent.
I will say the warrant says that there was an eviction at that apartment. So I may be misspeaking by saying it was the defendant who was evicted, but it definitely states an eviction was done by the Fulton County Marshals of that apartment.
Yes, and I said he was staying there under the belief that he could, Your Honor, and he didn't change locks or anything. So as I said, I do believe a signature would be warranted here.
And my response would be the judge has ruled.
All right. And no drugs, alcohol, or weapons while on bond. And I think that is it. Anything else, counsel?
Nothing from the defense.
Nothing further from the state.
All right. That should conclude this case.
We're completed here in courtroom 2, Judge. Thank you.
Thank you. Have a good one.
All right, you too. Thanks. Bye-bye.
Your Honor, there's a person, Ricky Williams, who waived his presence.
Oh, we have one. Let's see.
State's ready.
Oh, I see it. 21. Okay.
Yeah.
This is 22 CR 007144J. Ricky Williams is charged with 1 count of criminal trespass, offense date 10/23/2022. Pretrial.
41 total. Last arrest was in September for trespass. He's on probation. I'll put that in the chat for you.
Oh, okay.
He was arrested in July for trespass, obstruction. 2021 is what he's on probation for. 2020 probation violation, obstruction. 2020 obstruction, and what he's on probation for. Hold on. He was also arrested for that, along with the, Jay, you gotta look in the chat. Along with the obstruction and what he's on probation for. 2020 criminal trespass. 2019 trespass. 2019 possession of drug-related objects. Possession of cocaine conviction 2018. 2018 obstruction, sell of purchase, possession, control of substance. 2018, another possession of drug-related objects. Cocaine, probation. Yeah.
Okay. All right. Deputy Falk?
Yes, Your Honor. Let me make sure. Okay, I just want to make sure my audio, I wasn't unmuted. So this happened on October 23rd of 2022. This was a medical reset several times to allow the PD's office to obtain a waiver or to decide how to proceed. So this is not a Riverside issue. This occurred at 1225 Donald Lee Hollowell Parkway, the Bankhead MARTA station. Officers were dispatched at that location in reference to a disorderly person on the train. The train operator identified the defendant as the disorderly patron. He was removed from the train. He was asked for his breeze card, stated he did not have it because he left it at the station. The officers he then exited because he was asked to leave the station, walked around the block. The officers then observed him come back through and push through the fare gate without paying his fare. He then headed up to the platform. Again, he was told to leave the property and was given a verbal criminal trespass, telling him he would be arrested if he came back. He walked off again and then came back to the station. So, third time's the charm, at which point he was handcuffed and placed under arrest for criminal trespass. There was a permanent ban issued October 20th, 2021 from all MARTA stations, and it was effective October 20th, 2021. That is because of that public indecency conviction. We also have the fact that the defendant was convicted on criminal trespass from MARTA under 22 CR 006495J, which was in September of 2022, and in July of 2022, he had a criminal trespass under 22 CR 004429J, where he was also convicted. That was not in a MARTA station. The state, he also has criminal trespass convictions in 2019, 2015, total of 40 arrests. And so the state does have some concerns, especially with the sexual battery and public indecency charges, as well as the arrests and convictions from MARTA. We are asking for a $2,500 surety bond. If he stay away from all MARTA stations, there's already a permanent ban in place, so he's already in violation just by going back onto MARTA property. No alcohol, drugs, or weapons. That is all for the state.
All right, Ms. Holt.
Yes, Your Honor. Mr. Williams is 28 years old. He's been in Atlanta, as far as I can tell, for 8 years, and he is residentially challenged, Your Honor. He is not working, so he has no real financial means at this point. We will be having our social worker go and contact him. Obviously, he's not here, so she won't be contacting him while he's here. So we are going to have that, Your Honor. Given his situation, his very limited means, almost any bond is tantamount to no bond for him. So we would ask for the lowest bond possible of $500 surety if you're not inclined to do a signature bond. And then, as we said, as he said, he is very limited and has really no means or ways to make a bond.
And Your Honor, the state did omit, but we do have some MH concerns here.
Is anyone recommending we do an MH eval?
Yes, Your Honor, as I said, we'll be having our social worker go out and speak to him. He's not here, such that she could do it while he was in the courtroom.
And the state would request an MHET.
I think given his history, I'm inclined to order an MHET at this point to see what else we may have going on or what other services can be provided to him because of his history as well. So if you will prepare an order for me, Deputy Falk, I'll sign an MHET.
I know in speaking with Derek Howard from the PD's office, they prefer that the PD prepare the order.
Oh, okay. Ms. Holt, could you do that for me?
Yes, I'll do that for you, Your Honor.
Thank you.
And please send it to my attention.
Yes, to Ms. Bridgewater. And I'm going to give a $2,000 surety bond. And I'm going to, again, order him to stay away since he's got a permanent, what is it, a permanent 12-month ban or permanent ban
So
total?
this is a permanent ban. I actually have
ban.
not seen one of these.
Okay, right.
But this is a permanent ban.
Oh, okay. So he has a permanent ban from MARTA, so he's only gonna ride a bicycle, take Uber, or do whatever he has to do, but he can't ride MARTA. Or they have the face recognition, so he'll keep getting recognized. And no drugs, alcohol, or weapons while on bond. And again, stay away from all MARTA due to the ban.
Thank you, Your Honor.
Thank
All
you.
right, thank you.
That's it.
Is that it?
Should be. I don't have no more files.
Hmm,
That's it.
I believe that's everything, Your Honor.
So are
okay.
we ready to go over the calendar?
Yes,
Ms.
ma'am.
Bridgewater.
Okay, let's do it. Once again, the reset date for the SAP calendar is November the 8th. Position number 1 is reset further notice with a $5,000 total SOB through pretrial. Position number 2 is reset further notice as the defendant was released. Position 3, reset further notice with a $5,000 total SOB through pretrial. Position 4 is going to the SAP calendar with a $2,500 good bond. Position 5, reset further notice with a $2,000 total SOB through the jail. Position 6 is going to the SAP calendar with a $4,000 total good bond. Position 7 and 8 both took a plea. Position 9 is going to the SAP calendar with a $6,000 total good bond. Position 10 is reset to the SAP calendar with a $7,000 total good bond. Position 11 is going to the SAP calendar with a $4,000 good bond. Position 12, SAP calendar, a $1,000 good bond. Position 13 going to the SAP calendar with a $3,500 total good bond. Position 14 is being reset till tomorrow pending a transfer to the DA's office. Position 15 is going to the SAP calendar with a $3,000 good bond. Position 16, SAP calendar, $1,000 good bond. Position 17, reset further notice with a $2,000 SOB through pretrial. Position 18, SAP calendar, $1,000 good bond. Position 19, SAP calendar with a $1,000 total good bond. Position 20, reset SAP calendar with a $5,000 total good bond. And position 21, SAP calendar, a $2,000 good bond. Are there any questions, comments, or otherwise?
I'm good.
Nope, you're good.
All right.
All right.
See you all
everybody.
tomorrow.
All right.
Thank you.
Mm-hmm.
Bye-bye.
Bye-bye.